morning to everyone. It's a great honor for me to take part in this conference and to have the possibility to present my future paper titled "The Interaction Between the Rule of Law, Fundamental Rights, and Supremacy of the European Union Law." So I shall start with the changes of internal architecture of the European Union. The changes of internal architecture of the European Union and its predecessors over the past 2 decades have been firstly continuous over a substantial period of time, secondly quite gradual, and thirdly unidirectional, directed toward achieving an ever more unifying system, alignment of a greater number of interests, recognition of more common values, developing more powerful resources for protection of common interests and values, as well as towards an ever greater solidarity within the system. If one were to search in academic literature for a single most important quality that could be attributed to the development of the European law in the last 2 decades, then the process of constitutionalization of European Union law would stand out as the most prominent finding in most cases. So the constitutionalization of the European Union has been both a process and the outcome of the process of forming an ever closer union. Constitutionalization represents a synthesis of several elements: the legal order, the political substance, and the organizational structure. Legal phenomena articulating these 3 elements are the principle of the rule of law, encapsulates the essence of the legal order. Protection of fundamental rights has formed the political core of the European Union, while the principle of supremacy of the European Union has ensured the structural integrity of the European Union as a legal and political construct. Let me say something about the role of the European Court of Justice as an illustration of how gradual, continuous, and unidirectional these changes have been. One can take a look how the European Court of Justice has been developing various streams of the doctrine of autonomy of the EU law, and that doctrine has served as a wider basis for the European Union law claim to supremacy vis-à-vis member states' law. It is evident that the court, Luxembourg Court, has persisted over the course of 5 decades to use the so-called autonomy of the European Union law as the foundation for building a body of case law that would all point into one direction regarding the European Union law as a self-contained system ruled only by its own internal set of values. Constitutionality, not merely legal, but also a political category. Constitutionality is not a purely legal category, it is also a political one. Constitutionality of any given political legal system is unimaginable if that system does not recognize and promote certain core values of its own. Values of the European Union are set forth in Treaty of the European Union. Objectives of the European Union are directly based on the values of the EU, and the treaty enlists a catalogue of values which must be promoted by the EU in its external action as well. A particularly solemn expression of these values of the European Union since 2000 has been the Charter, of course, Charter of Fundamental Rights of the EU. It is notable that a plurality of sources of basic rights exists, and basic rights are one of the key constitutional values of the European Union. Article 6, paragraph 3 of the Treaty of the EU stipulates that both the fundamental rights guaranteed by the European Court of Human Rights and those that stem from common constitutional traditions of the member states form general principles of the Union. the outcome of the development of the European Union so far, which are the question on what exactly is the legal nature of the European Union remains unanswered still. It is neither a state nor an international organization. Some authors argue that it is a radically new political form. Some say it is a sui generis entity. The only notion offered by the founding treaties emphasizing the dynamics rather than nature, it is an ever closer union. The only other qualification that the founding treaties put forth in respect of the nature of the European Union is that it is a union based on law. The European Union Court of Justice regards the law of the EU as autonomous from any other legal system and body of law that may be imagined. Substantial portions of executive, legislative, and judicial powers have been transformed from member states to the European Union institutions. The claims to competence by the European Court of Justice have so far not been denied in practical terms. The European Union perceives itself as a value-based community, so that it bestows great importance and authority upon its Charter on Fundamental Rights. All these are powerful and undeniable symptoms of a sovereign political creature. But can a non-state entity be sovereign? Classical theory ties firmly the quality of constitutionality to the quality of sovereignty of a given political community, whereby sovereignty is regarded as absolute and indivisible. Speaking about the existence of the formal aspect of sovereignty, for example, Dumont admitted that although sovereignty needs to be only one and indivisible, most of the solution to the issue of the EU sovereignty lied in the alleged autonomy of the EU legal system. The same connection between abandoning the classical concept of the absolute and indivisible sovereignty and understanding the legal nature of the European Union is advocated by the Robert Schulze as well. The bottom line seems to be that if one wishes to understand the legal nature of the EU, then one must abandon the concept of the indivisible sovereignty. So the constitutionality of the European Union is by no means an ordinary one. Most scholars agree that the striking peculiarity of the European Union, of the EU constitutionality, is the manner in which it had been conceived without relying on the will of a classical political community. It means of a nation with coherent political identity and values. And where exactly lies the constituent power, pouvoir constituant, within the European Union? It is voluntary character of collective actions of European Union member states, which have persisted for decades, that Ulrich Preuss identifies as the principal evidence of existence of an EU constitutional power. In the foreword to the collection of papers of the European constitutionalism after the Lisbon Treaty, for example, Wouters, Verey, and Kiever present their view that in development of the EU, constitutionalism is the classical sense may not be found. They argue that instead of it, two other forms of constitutionalism may be recognized. Firstly, political constitutionalism in the form of public debates on the Constitution of Europe, and secondly, constitutionalism embodied in the doctrine on the autonomy of the European Union law promoted by the Court of Justice of the European Union. Apart from describing the present state of affairs of the EU, the utility of the concept of the constitutional pluralism seems to be limited. The grounds for such assessment are manifold. On the general level, the concept contradicts itself. If constitution is understood as a set of norms on the highest authority, its competence and limitations, as well as on protection of core values of a political community, then it is difficult to imagine peaceful coexistence of two such acts. In a historical perspective, it is difficult to identify a single political community in which several such sources of law coexisted. And for these reasons, real constitutional pluralism does not seem to be sustainable within a single political community. In addition, the European Union is changing rapidly and profoundly, so the present state of affairs may not be considered relevant as ground for broader conceptualizations. In this paper on the concept and nature of the EU constitution after Lisbon, for example, Leonard Besseling proposed a three-pronged view on the functions that a constitution must perform. Constituent function in the sense of establishing the supreme political authority, attributive function in respect of the powers of the public authority, and regulatory function consisting in providing legitimate restraints for the power attributed to the public authority. Besseling explained that only the last two functions, attributive and regulatory, must in fact be performed by every constitution, while performance of the constituent function must be satisfied only by revolutionary constitutions. He argued that the European Union is a political community based on an evolutive constitution. It should also be pointed out that there are very useful historical examples, and indeed a very successful and influential one, of both evolutive constitutionality and of plurality of constituent powers, that of the, for example, of the English Constitution. I have attempted to provide in this paper a synthetic view on the dynamic nature of the European Union, which is an encrypted phenomenon. One needs to know how to read between the lines in the case law of the Court of Justice of the European Union in order to be able to find pronouncement on the legal nature of the EU, because the subject matter cannot be found in the founding treaties. The synthesis, which I have tried to make, encompassed three facets of a state: law, structures of power, and legitimacy. According to this approach, the European Union may be explained in a theoretically coherent fashion. On the legal plane, not several, but one constitution exists at the EU level. That constitution is not a formal one and certainly belongs to a category of evolutive constitutions, and there is a plurality of constituent powers. The rule of law binds the outputs of those powers into a single legal order. In terms of power, conceptualized as sovereignty, it is divided among the European Union and, of course, its member states. So, in this respect, the European Union is more similar to a medieval commonwealth than to modern nation states. And in respect of legitimacy, democratic representation is not abandoned, and it is being strengthened. Furthermore, legitimacy is secured by the purpose of the European Union, the protection of universal fundamental rights. I shall stop here, and I will thank you very much for your kind attention, and I'll be glad to. I'm looking forward to discussion. Thank you very much.